Mr. Richards, I think you're going to address us for the next hour, is that right?
I'm sorry, my Lord.
Address us for the next hour, is that right?
Well, I hope so, my Lord. I'm concerned only with issues 3 and 4.
I mean, if that's an indication you might take less, that'll be very welcome.
I'll do my best, my Lord.
Thank you.
My Lords, issue 3 is concerned with another aspect of whether policy is out of date.
Yep.
The Suffolk coastal local plan policies, which we're concerned with, are policies SP 29, 27, 19, 27 and 29, and those relate to development within and outside of what are called physical limits boundaries. And you were taken to a plan which is at tab 55, a coloured version of the plan, and the physical limits boundaries are shown in red, you'll recall.
Yep.
Issue 4 is a discrete point and separate from the whole of the question of whether or not policies are out of date, and it's concerned with the correct approach to the assessment of impact on non-designated heritage assets. And I'm going to start with dealing with issue 3, which is concerned with physical limits boundaries. And I think I submit that the question to be determined by the court is whether the inspector erred in treating the policies relating to development outside the physical limits boundaries as up to date in finding in the decision letter that the site was outside the physical limits boundaries as defined in the very recently adopted local plan. And the words very recently adopted are the most controversial part of that sentence. That's at the decision letter at paragraph 13, and it may be useful if Lords could take the core volume.
MS 349, page 94, I think.
It's in Appendix 1 at page 92. And the particular paragraph is at page 94. And it's the finding that the appeal site is outside the physical limits boundaries defined in the very recently adopted local plan. You need, of course, tab 55 plan to see that the site, how it relates physically to the red line of the physical limits boundaries, because the site, of course, is wholly within the country park, the historic park that is associated with Grove Park that you were taken to this morning by Mr. Kingston. The key proposition that Hopkins Homes have relied upon in this is in the set out in their case at page 245 of the core volume. And if my Lords could turn that up.
Yep.
And it's probably best to read from 49. There is the reference to paragraph 13 of the decision letter that I've taken you to. And then at 50, that was an error. The boundary was merely carried over without scrutiny or review from the old local plan. And then it refers to Appendix D to the local plan, which states that the actual proposals map will be updated when they're superseded by the adoption of subsequent development plan documents. And then the key proposition is encapsulated in paragraph 51. The boundary's age should have been correctly noted by the inspector in the context of the importance given by the NPPF to up-to-date policies, see particularly paragraphs 12 and 14. And that proposition raises effectively 2 points. The first is, was the inspector wrong to find as fact that the site was outside of the physical limits boundaries defined in the, in quotes, recently adopted local plan? And secondly, if so, did any error as to the age or indeed the provenance of the proposals map amount to a material error of law? First of all, dealing with the factual position so far as the physical limits boundary is concerned, the local plan is in Authorities Volume 4B at 2, and I'd like to invite
Page?
my lords 2542.
Thank you.
4B.
Yep. Thank you. Thank you.
And there is a definition of the physical limits boundary. The defined line within which new development will normally be permitted, often referred to elsewhere as village or town envelope, depending on the settlement. The physical limits boundaries for major centres, markets, towns, key service centres and local service centres will be defined on the proposals map. Outside the boundaries, the area is defined as countryside. Now, the proposals map itself, of course, is not a development plan document in its own right. It's incorporated by reference into the new local plan. And whilst it was carried forward from the old plan, it was carried forward with amendments. And if we look at Appendix D in the plan, that's at, again in Authorities 4B, 2551. Lord will see that as a consequence of the adoption of the core strategy, particularly policy SP19, a number of settlements within the district have had their physical limits boundaries removed. And then it goes on to say, in the last line, the actual proposals map will be updated when they're superseded by the adoption of subsequent development plan documents. So they weren't carried forward blindly. They were effectively, a review took place in the light of the new policies, and the physical limits boundaries for a significant number of settlements were deleted altogether.
Is that explained somewhere? Why that was done for some and not others?
It's the reference back is to SP 19, I think, my lord, which explains this. And there is.
Where is that?
That is at page 2459. And effectively, those were settlements which were other villages, which were not where it was not considered necessary to define a physical limits boundary because they were wholly within the countryside. If the Lords were to go to paragraph 4.05 on page 2458. It says this: to further facilitate and guide the location of development at the larger settlements, physical limits boundaries or village envelopes will be drawn up. It should be noted that physical limits boundaries are a policy tool and do not necessarily reflect the full extent of the town or village. Indeed, where allocations are proposed, these will be cited outside the settlement envelopes. The envelopes will be redrawn to include them once the site has been developed. In essence, they serve to differentiate between the more built-up areas where development will normally be considered acceptable and the countryside Policy SP29, where development will be strictly controlled in accordance with national planning policy guidance, and otherwise not permitted unless in conformity with the strategy for the countryside as set out in Policy SP29, which includes other small-scale, locally supported schemes.
But when it says the limits boundaries will be drawn up, how does that relate to the ones which will be just carried forward from the previous plan?
Well, I think you've heard, my lords have heard already that the approach that was taken in this local plan was that there was to be a review.
Yeah.
And Lord, at page 2553, you were taken this morning to the policy overview and the table there. And you'll see that the policies that we're concerned with here, SP 19, 27 and 29, under sustainability objective. But there is a note, effectively, in the margin there. It's under development management policies, but it's a note which relates to that, which says site-specific policies will follow in the site-specific allocations and area-specific policies document, area action plans and neighbourhood plans. And if one can put a mental thumb on that and then go to policy SP2, my lord, this is the policy that all parties agreed was a policy for the supply of housing, and the inspector treated it as such. That's on page 2426. And it says this: an early review of the core strategy will be undertaken, commencing with the publication of an issues and options report by 2015 at the latest. The review will identify the full objectively assessed housing needs for the district and proposals to ensure that this is met insofar as this is consistent with policies in the National Planning Policy Framework. So the position was that in the short term there would be a reliance on the provision made in SP2 for housing numbers and distribution. There would be an early review, and as part of that early review, there would be a DPD, a development plan document, which would deal with the questions of allocations. And that would be the time at which a thorough review of the physical limits boundaries would be taken. So for the time being, the physical limits boundaries plan was the plan that through which the policies SP 19, 27 and 29 identified the physical limits boundaries. And in that sense was
yeah, I mean, as a matter of pure accuracy, it was as in the very recently adopted local plan, but the point that's being made is, well, that doesn't mean very much since it's by definition under review.
Well, it would be under review.
Well, if and when there's a housing need, so when you find there is a housing need,
yeah,
why shouldn't you review it?
Indeed, but the pending the review, the physical limits boundaries for the up-to-date plan remained as defined in the proposal's map, so far as Yoxford was concerned, at least.
I'm sorry to be rather slow about all this, but this seems to me to be a slight element of the tail wagging the dog. And so, in the great scheme of things, what's the significance of this point?
Well,
and if this were the only point upon which we won...
Well, the reason for dealing with this point is that this was a point on which the Court of Appeal found that the...
Well, Mr Justice Supperston found.
And Mr Justice Supperston found
Court of Appeal.
That the inspector had erred.
If there wasn't an error, well, that gets you a step further down the way.
That's right.
But it seems to be a fairly sort of... I don't know quite how to describe it. I mean, you've got a policy which isn't a sort of finely adopted boundary. It's a boundary which, by definition, is subject to review. And so it seems slightly odd to put a lot of weight on that being a sort of recently adopted boundary.
Well, the question of weight is, of course, for the inspector to
Anyway, that's the point.
determine. The point is,
That's it. Yeah.
but it's not that he misdirected himself. The allegation of error is actually that he misdirected himself as to what the status of that policy was. And our position, our submission is that he didn't. He understood it very clearly, and he was right in saying that it was defined in the up-to-date or the recently adopted plan.
But it's a short point.
Indeed, and I suspect that I can go forward from there, but it's perhaps important to turn to the second issue that arises from the proposition, which is, if we're wrong about that, what is the consequence of the age of the proposals map? A mistake as to the age or provenance of the proposals map, so far as the question of whether or not the policy is out of date for the purposes of paragraphs 12 and 14 of the NPPF. And that's an issue in which we rely on the case of Daventry, which is in the authorities, volume 3, at tab 37. And I can go quickly to the paragraph, the key paragraph in here, where Lord Justice Sales,
Where is this?
I'm sorry, tab 37 in volume 3.
Thank you.
What do you mean? I just wonder why one needs authority on this sort of point. Where do we go?
Well, and I was going to invite your Lordships to look at paragraph 40
Not binding authority.
No, right there.
of this, where he sets out, Lord Justice Sales sets out the position so far as old plans are concerned. It's our submission that out of date means one of three things in the context of the framework. First of all, it's deemed out of date because no 5-year housing land supply, and you've heard about that this morning.
Yeah.
That's covered by Mr. Kingston. Secondly, it's where it's inconsistent with the framework in accordance with paragraph 215 of the framework. This is under Annex 1, which deals with effectively the transition.
Which page are we on?
259 of Annex 2.
Going back to the framework.
In the
Appendix
framework.
2, Annex 259. Very well, thank you. Yep. Annex 1, I see. Thank you. Paragraph? You said the paragraph.
215.
Thank you. Yes, I see.
And the key part of 215, this is dealing with the process of what should happen to old pre-NPPF development plan policies. And 215 says this: in other cases and following the 12-month period, due weight should be given to relevant policies in existing plans according to their degree of consistency with this framework. The closer of the policies in the plan to the policies in the framework, the greater the weight that may be given. So the second basis on which a policy can be out of date is that it's inconsistent with the framework. And of course, neither of those meanings, the curious thing about the words out of date in the framework is that they're not concerned with out of date in the sense that we normally mean. In other words, something to do with being chronologically old. There is, I suppose, and would submit a third category of out of date, which is where they are as a matter of planning judgment out of date because their time expired and no longer consist of a useful or up-to-date expression of local policy. But what is said in Daventry is very clear, that And if I invite your lordships to look at paragraph 40, little Roman 3, the fact that a particular development plan policy may be chronologically old is in itself irrelevant for the purposes of assessing its consistency with policies in the framework. And it's therefore our submission that even if they're right about the fact that it is an old policy, that doesn't mean that it's to be treated as out of date.
Well, of course. I mean, that's obvious, isn't it? I mean, something could be long-standing, but still valid.
Indeed.
And barristers and judges have to act according to the law is old chronologically as a rule, but is still not out of date.
It can be perfectly up to date, even though it's not, even though it's old.
I mean, that's not true of this one. You know, the Green Belt policy is one of the sort of most long-standing policies, and when people try to change it, people pray and aid the fact that it's been there for a long time. But where you've got a policy which specifically says it's going to be subject to review in the light of further housing need, then it's a different case.
Indeed, but of course, the position that the inspector or any decision maker is in with this policy is that it is, for the time being, the policy to which the recently adopted local plan applies, and it's the basis for determining whether or not the policy in SP 19, 27 and 29 are actually applicable to this site. The weight that he gives to them is then a matter for him, and the inspector in this case would have been entitled to have treated it as a policy which was one which was going to be subject to review. But if he'd done that, the difficulty would be that he would be anticipating...
He makes this point, but he then goes on to say it's in an important position adjacent to the settlement where the old high road marks it. I mean, he makes a planning judgment. I mean, that's what seems so unrealistic about all these arguments. They seem to sort of treat these words of the planning policies as though they're sort of gospel or statute, without seeing what the inspector did with them.
Indeed, and of course what the inspector did in this case was actually to look at the merits of the proposal, having regard to the policies, and to consider them in that sense. Well, it's on that basis that it's our submission that that there was no error of law in this. That those words in paragraph 13 don't disclose an error of law, and the question of what weight to attach to the local plan policy was a question for him. He hadn't misdirected himself or misunderstood how the policy worked, and there was no suggestion in any case, that even in the position of a review, even in the situation of a review, that the boundaries of the physical limits boundaries of Yoxford would be varied so as to include part of the specially identified landscape area and historic park of Grove Park. Unless I can help you further on that particular point, I'm going to move on to issue 4, if I may. And that concerns the question of heritage assets. The question in this case is whether the inspector erred in failing to assess the effect of the development on the significance of the historic parkland as a non-designated heritage asset. The term heritage asset is defined in the glossary in the NPPF. Page 263 of Appendix 2. And in this case, it includes buildings, monuments, sites, places, areas, or landscape. Clearly, in this case, we were concerned with former parkland of a historic country house. So it qualified as a heritage asset as a landscape identifying a high degree of significance meriting consideration in planning decisions. Policy in the framework distinguishes between, well, policy generally distinguishes between designated and non-designated heritage assets. And in the glossary in the framework, a designated heritage asset is one which is designated under relevant legislation.
Yes.
And that's usually either a listed building or a registered park or a scheduled ancient monument, depending on which is the legislation in play. But non-designation is not in fact defined, but it must be just the corollary of that. It must simply be a heritage asset which is not a designated heritage asset. But it's an important distinction because the policy approach taken in the framework, in Chapter 12 of the framework, is to create a hierarchy of heritage assets and their treatment in planning decisions.
The key to it in the definition is that they've been identified by the local planning authority as heritage assets, even though
That's
not
right.
designated.
It's a local designation.
Yeah.
But so far as the framework is concerned, there is a difference in treatment of assets depending upon their importance. And of course, we're familiar with listing grades of 1, 2-star, 2.
Yes.
And each of those is given consideration in Chapter 12, which starts on page 241 of the framework.
Thank you.
Which is on page 241. And paragraph, the starting point is in 126, and I'm not going to read out parts of that, save that it enjoins local planning authorities to set out in their local plan a positive strategy for the conservation and enjoyment of the historic environment. I'm not sure how clear my Lordship's heading is there, but the heading in Chapter 12 is conserving and enhancing the historic environment. And then at paragraph 128, in determining applications, local planning authorities should require an applicant to describe the significance of any heritage assets affected, including any contribution made by their setting. And it then says this: the level of detail should be proportionate to the asset's importance and no more than is sufficient to understand the potential impact of the proposal on their significance. And then it develops that a little. Turning over the page, to 242, paragraph 131 requires them, in determining planning applications, local planning authorities should take account of the desirability of sustaining and enhancing the significance of heritage assets and putting them to viable uses consistent with their conservation. Positive contribution that conservation of heritage assets can make to sustainable communities, including their economic vitality, and the desirability of new development making a positive contribution to local character and distinctiveness. And then one has a sequence of paragraphs. 132 starts, when considering the impact of a proposed development on the significance of a designated heritage asset, and then you've got the consideration of what happens there. Of course, that doesn't apply here, but the degree of harm to a designated asset is clearly treated in a particular way. And the grade, etc., of the listing or designation is also important. 133 is also concerned with development which leads to substantial harm or total loss of significance of a designated heritage asset, and sets out a number of points that have to be applied. 134 deals with the question of where there's less than substantial harm to a designated asset. And it's only when we get to 135 that we consider the effect of an application on the significance of a non-designated asset, which should be taken into account in determining the application. And in weighing applications that affect directly or indirectly non-designated heritage assets, a balanced judgment will be required, having regard to the scale of any harm or loss and the significance of the heritage asset.
So does the designated or non-designated heritage asset get a mention in the inspector's report?
Yes, it does.
And where is it?
And in due course, I'll take your lordships to how he deals with it. But it's clear that a historic park such as this qualifies as a heritage asset, as a historic landscape. It is locally designated. My lord, you were taken to SPG 6 earlier, which is in Appendix 2, Part 2, page 616, and Policy AP 4, which applies, which is a saved policy. And the policy therefore requires, in this case, that the park, which is within a special landscape area, because it is a historic park, should be protected by policies applying to special landscape areas, which require that the proposal will not have a materially adverse impact on the character, features, and setting of the historic parkland. And for your lordship's note, AP4, which you visited earlier with Mr. Kingston, is at 595. And that is the policy that applies the SPG and requires, turning over the page to 596, that in considering applications, the bottom of the page, in considering applications for development, the District Council will ensure that proposals will not have a materially adverse effect on the character, features, or setting of a historic parkland. And finally, the policy itself, parks and gardens of historic or landscape interest, that's on page 597. The District Council will encourage the preservation and or enhancement of parks and gardens of historic and landscape interest and their surroundings. Planning permission for any proposed development will not be granted if it would have a materially adverse impact on their character, features, or immediate setting. And we've then got the policy AP13. So they're double protected. Parks are double protected under these policies because AP13 designates the parks and gardens of historic or landscape interest as special landscape areas and shown on the proposal's map. And that's 597.
Do we know why these had to be saved rather than included in the new plan? I mean, we've got an up-to-date plan approved in 2013. Why do we still have saved plans from an old plan? Saved policies from an old plan?
I think because that would be dealt with in the more detailed review at that stage and considered at that point.
So these are by definition subject to review.
I can't speculate on precisely what the reasoning was for that. But certainly those policies were to be reviewed in due course. And the case that's put by Hopkins Home is summarised in their case at, if we return to the core volume, paragraph 57 on page 247. And they make 3 points under paragraph 57.
Yeah.
The first is all of this is in the context that this was the respondent's case as summarised by the Court of Appeal. First is that the inspector addressed himself to the topic of local historic parkland by reference to the 1995 SPG. But at that time, national policy in relation to historic buildings and areas is quite different. The concepts of heritage assets and the assessment of their significance not being present. So the first point they're making is that national policy has changed. The second that they make is that the inspector's wrong to claim that AP4 is broadly consistent with national policy. And the third point that they make is that the inspector failed to grapple with the question whether the development would harm the significance of the historic parkland as a heritage asset, and if so, how? And dealing with each of those in turn, as far as the first one is concerned, there is, in fact, nothing in the Court of Appeal, or indeed the divisional court's judgment, Court of Appeal's paragraph 64 that we're referred to, simply makes no reference to the SPG being out of date because it was drawn up under different policy. And so it's a novel claim which is completely unparticularised. We're not told in what respect the policy is supposed to have changed. But in any case, it's our submission that it's wrong because the policy and has always sought to preserve and enhance the character and appearance of places of historic interest. And that's actually reflected in legislation. But it was not part of the respondent's cases put to the inspector or the courts. And we're not able to deal with it here on a reply to a response, as it doesn't appear to have formed part of either Mr. Justice Supperston or Lord Justice Lindblom's judgments. As to the second point, the question of whether it was wrong, the inspector was wrong to claim that AP4 was broadly consistent with national policy. If I could invite your lordships to turn to paragraph 10, again, going back to the decision letter, we can see how the inspector deals with this. Policies AP4 and AP13 are saved policies within the old local plan. Policy AP4 states that the council will encourage the preservation and or enhancement of parks and gardens of historic and landscape interest and their surroundings, adding that planning permission will not be granted if development would have a materially adverse impact on character, features or immediate setting. The appellant suggests that this policy does not allow for a balance of harm against the benefits and so is not consistent with the framework. And stopping there, that's clearly the approach that was taken at the inquiry. That was the submission that was made, and the inspector deals with it. Policy AP13 relates to special landscape areas and states that no development will be allowed which would be a material detriment to or detract from the special landscape quality. The appeal site falls within a defined SLA, and the parks and gardens of historic and landscape interest are designated as SLAs. With respect to the advice in paragraph 215 of the framework, I find there is a degree of conflict between policy AP4 and the framework due to the absence of balancing judgment in policy AP4. However, its broad aim is consistent with the aims of the framework and planning practice guidance. And in this respect, I find and these, I think there's a typo there. I find that, and these matters reduces the weight that I attach to policy AP4, although I shall attach some weight to it. Appellants are similarly critical of AP13. However, I note that the PPG and the framework recognise the intrinsic quality of the countryside and promote policies for the conservation and enhancement of the natural environment, and to this extent, policy AP13 is consistent with those aims. So where that takes us to is that first of all, we can see that the inspector is plainly considering policy AP4 as an old policy in accordance with NPPF paragraph 215, and it is effectively a question of planning judgment whether it's inconsistent, and he has reduced the weight. He hasn't treated it as being given full weight. He's treated it as having a reduced weight. That finding can only be challenged on grounds of Wednesbury unreasonableness. But in any case, it's our submission that he was right to find that the policy was broadly in accordance with national policy in seeking to preserve or enhance the character and features and setting of the historic landscapes, which is the wording in AP4. That broadly echoes Chapter 12. And I pointed to the heading earlier, which was the heading is Conserving and Enhancing the Historic Environment. It's clearly directed at precisely the same point. But Hopkins Holmes' third point is
what about the monument? Does the monument get a mention?
The monument?
The monument. The one that we were looking at before. Historic buildings and the like. Well, never mind.
We only got Parkland. I don't think we've got a monument.
We're only dealing with the park.
We're only dealing with park.
Only dealing with the park, my lord.
He does go on at the end of this to talk about the planning balance. So if you need a balance, you've got a bit of a balance at the end of this.
Yes.
But he doesn't deal with it specifically in the context of 215, but he does look at it more generally. So
Indeed, my lord. But the real meat of their case is their complaint the inspector failed to identify the significance of the asset, and then failed to identify the harm to the significance of the park as a heritage asset rather than as a landscape. That reflects the findings of the Court of Appeal on the absence of a separate and distinct assessment of significance of the asset. But it's my submission that there's nothing in the relevant framework policy that says that an assessment of significance for the purposes of assessment of an impact on a historic landscape must be an entirely separate exercise from assessment of landscape and visual impact. If we go to what's said by the inspector at paragraphs 15 and following, what we find is that 15 identifies the site as forming part of an area defined as historic parkland by the council in SPG 6. The house at Grove Park is said to date from the late 16th century, rebuilt in the 1770s. Then the SPG identifies the southern section, including the appeal site, now in arable use, but that some parkland trees remain, and adds that notwithstanding the presence of the cricket ground and the then planned bowling green, the essential qualities of the park remain. And the SPG notes that boundaries of the parkland have been drawn taking account of that area currently forming the visual extent of parkland and any additional area which historically formed part of the extent of parkland and which continues to display remnants of that former park. And then he goes on to consider what's happened since the SPG to see whether
we
that
got
still
all
applies.
this, and you say that goes into it, and he says it's unacceptable. Yeah.
And we say that if one goes to the definition of significance in the glossary of the NPPF,
Why do you need a definition of significance? You know, it's cloud cuckoo land. All that. Significance is an ordinary word, and you apply it. But
well, my lord, there it is. But significance is defined But it's my submission that it has no special or
It
magical.
has no significance.
Indeed.
I see. Okay. Well, sorry, I don't want to diminish its importance. It's significant.
Yeah.
Significance for heritage policy. We're on page
Yep.
267.
Thank you. I see elder people are defined as well.
The value of heritage, and it's defined as the value of a heritage asset to this and future generations because of its heritage interest.
That is very illuminating.
That interest may be architectural, archaeological, architectural, artistic, or historic.
That's an exclusive.
Yes, that's right. Well, yes. And the significance derives not only from a heritage asset's physical presence, but also from its setting. So what actually constitutes significance doesn't have any special or unusual meaning. It's our submission that in looking at the features of the park and identifying them, he's clearly identified that it's identified as historic park, it's associated with a historic house, it's got parkland trees, the essential qualities of the park remain, that the key underlying qualities of the park, he says, the openness and freedom from built development remains, and it has the existence of parkland trees, the historic association with the house, the entrance at the southeast, perimeter wall, and so on, all qualify as remnants of the former park. So that provided him, he was entitled to rely on the SPG and his own site visit and the evidence that he'd seen as providing the basis for identifying the significance of the park. He then turns, after paragraph 16, to looking at the historic parklands, first of all in 17 as special landscape areas. But of course, as special landscape areas, they are also, the reason why they are defined is because they're as special landscape areas and are subject to policy AP 13, is that they are historic parklands. And so there is a nexus between the application of paragraph of policy AP4 on one hand, and which is specific to historic buildings and landscapes, and AP13, which is concerned with SLAs, which includes.
He's been through it all. We can read that for ourselves.
My lord, yes.
The other side will tell us why it's not enough.
Paragraph 21's all you need, isn't it?
Indeed, and my lord has taken me to paragraph 21, which is where he weighs these matters up. It says, in respect of these matters, the historic parkland forms a non-designated heritage asset, as defined, and conclude the proposal would have an unacceptable effect on the significance of this asset. And he's reviewed all of the aspects of it, including its landscape character and value. There was no, and it's my submission that this is a necessity.
Well, you just simply say, there it is, he's taken all relevant circumstances into account, and that's all there is to it, really.
Indeed, and he's not, there's no other assessment in front of him.
Well, it's a short point again.
Indeed, perhaps I'm making more of a meal of it than I ought to. But the long and the short of it is that
Well, the long and the
Inspector
short
and the
of it
Court
is
of
the point
Appeal.
I put a moment ago, and that's surely the end of it.
I'm sorry, my lord.
The point, it's really the point that my lord and I put to you a moment ago is your case, and that's really an end of it, isn't it?
It is, and one can test the approach that's taken by reference to a whole series of decisions which were set out in our case. But the long and the bottom of it is that the inspector's not writing an exam paper, etc. He's an excessively forensic approach is not the approach to be taken. The report, his inspector's report and decision letter is to be read as a whole. This is an expert tribunal.
You've got all that. We read
All of that is well-trodden territory, my lord, yeah. And so, as to the balanced judgment, he was clearly aware of that requirement. He refers to it expressly, and he carried it out under a heading which is called the planning balance, which is in paragraphs 31 and 32, which Lord Carnworth took us to in the first place. So our position is a very straightforward one on this. He did carry out the exercise in a sufficiently clear way. He gave his reasons in a sufficiently clear way, and there was no error of law in this, or nothing that could amount to an error of law that would justify quashing his decision. And it's quite clear, to anyone, and particularly to the parties to the inquiry, what was the basis on which he was finding that the development was unacceptable effect on a historic landscape recognised in policy. Lord, unless I can assist further, those are my submissions on that point.
Thank you very much indeed. Thank you, Mr. Witt.
Very much.
Mr. Lockhart-Mummery.
Thank you, my Lord. I'm going to start, if I may, by attempting as shortly as I can an answer to the court's letter that came round, I think, last Friday, the 16th of February, seeking guidance as to the reference jointly by the parties to the royal prerogative in the judgment of Lord Justice Laws in West Berkshire. And Lord, we have put together, courtesy mainly of the Secretary of State, the white file that was provided to the court. And my purpose in these opening comments is to give our answer to that matter, and in the course of that take as brief review as I can to the history of statutory provisions, very briefly getting to the present state of those provisions.
Is it your position that Lord Justice Laws was right?
No.
And is it the Secretary of State's position that he was
No.
right?
He on that point is the same. We diverge very slightly, I think, on some of the...
Is anybody defending Lord Justice Laws?
Not that I'm aware of, my Lord.
Well, then you can take it fairly shortly, possibly, or maybe not.
Well, I'm not going to make a great thing of it. The court has sought guidance.
Yeah.
If I may take a brief review of these matters,
Yes.
because I think it will assist my Lord's background to the determination of these appeals.
I think it certainly, for my part, and I was one who sort of started the hair running, I think it is important to be clear what power he is exercising.
Yes.
And certainly the other side have made something of the fact that he deliberately didn't go for a statutory provision in this, and so we want to see what his power is.
Well, my Lord,
Could you assist before you go through the material by giving a sort of
yes.
short summary as to
My conclusion-
where you're going to end up?
My conclusion, which I stated at the outset, my Lord, is that the power to issue guidance such as we have, policy and guidance such as we have in MPPF, is integral to the statutory scheme and or a necessary adjunct to the specific statutory powers.
Thank you.
That's where I'm going to end up. And my Lord, a brief review, if I may, by reference to this white file. My Lord,
There are a
tab
lot of
one.
documents in your file.
A lot of
A lot of
documents.
documents in your
My
file.
Lord,
You haven't got a one-sheet paper on which your submissions are, have you?
no, my Lord, but I've got about a quarter of an hour's comment on them, and I promise you I'm going to...
Right.
Please don't be daunted by the file, because I'm going to...
Well, most of it is our judgment in the Miller case, isn't it?
I'm not daunted by the file.
I'm not-
We have your conclusion.
You have,
I'm
you
happy
have my
you go-
conclusion, my
you
Lord.
know,
I just want to take
tell
a
me how you
brief
get there.
historical route, if I may. Tab 1, my Lord,
Sorry, just before you go on,
where in 1943...
Yeah, wait, I think Lord Gill was asking you.
I'm
just
so
before
sorry.
you go on, you've identified to us the source of the Minister's power. What's your conclusion as to the scope?
Yeah.
Well, my Lord, the scope is
That's the important point.
a substantial involvement in the formulation of the development plan, both in terms of the two principal limbs of the development plan as we now have them, local plans and neighbourhood plans, which are important. And my Lord, secondly, I will in due course briefly just remind the court of the very extensive powers of the Secretary of State in development control or development management, as we must now call it, which have always been in place, including call-in of planning applications, determination of appeals, and a whole host of other matters, for the proper and orderly discharge of which the Secretary of State may promulgate policy so that the public, planning authorities and the world at large know where he stands on when he exercises these powers. Lord, can I go briefly to tab 1 of the white folder? There was, in 1943, a power to issue national policy. That was at the stage when there were not development plans. There were things called interim development schemes, but there it is, an express power. And tab 2, that power was repealed in the Secretary of State for Environment Order 1970. For our part, we've been unable to find any rhyme or reason for that repeal, but in tab 2, I think it's paginated in the electronic copy, which I'm not using, but in the internal pagination at the top, page 20, please, towards the end of tab 2, you'll see in the repeals, 5th down, 1943 Act, sections 1 to 7 repealed.
There was, I seem to remember, an article in the JPL, headed "Whatever Happened to the Minister of Town and Country Planning."
Well, you're
I
ahead
don't
of
say
me.
you need to dig it up. I think it didn't have an answer.
I don't know. I didn't remember that, and I haven't looked at that. My Lord, jumping forward, although just being aware that in 1968 we had the 1968 Act, which of course followed the Consolidation Act, the Modern Act of 1947, that itself being consolidated in 1962. We then had the introduction of what were then regarded as the modern development plans, that's to say structure and local plans. We then get to 1990, where there is the present Act, which was both a consolidation and an Act containing new provisions. And, my Lord, if you go to tab 3, please, this is the 1990 Act as originally enacted. And for the first time since the 1970 repeal, we have the role of the Secretary of State. In section 12, this is preparation of unitary development plans, which are now fallen by the wayside. But, my Lord, see subsection 6, in formulating the general policies, have regard, A, to strategic guidance given by the Secretary of State and to current national and regional policies. So what went out mysteriously in 1970 starts to come back in 1990. One sees that also in relation to structure plans in a slightly different form on the next page, or within tab 3, section 31, you'll see subsection 4A, a duty to have regard to current policies with respect to the economic planning and development of the region as a whole. And that again was a Secretary of State power, not a national guidance, but RPG, regional planning guidance, which in those days was made and issued by the Secretary of State. Well, we then come chronologically to the 2004 Act. And, my Lord, may I just pick up a point from my Lord Conworth? Two points you made, my Lord, in discussion with Mr. Kingston. You said that the 2004 Act introduced a much more elaborate code. With respect, I personally wouldn't accept that. The code that we've got now is substantially, not in its details, substantially the same as in the 1970 Act and subject to the local plan or development plan regulations of 1974. And those regulations have been repealed and reissued and repealed and reissued over the years till we get the present regulations. But they required the same levels of consultation, notification, regard being had to various factors, examination, and so forth.
Yep.
So I caution, my Lord, most
No,
respectfully.
well, I certainly would accept it from you, because you've dealt with them both. What about section 38.6? So
that was my next point, my Lord. My Lord said, and this is obviously a slip of the tongue, if I may say so, that we didn't have that before.
We did.
We had in section 54A of the 1990 Act,
Yes.
which was introduced by the Planning and Compensation Act of 1991. And if one casts one's mind back then, the Conservative Party was very keen to have primacy to the development plan and local interest and so forth. And so section 54A was inserted, and save for one little word, I think, it is identical to section 38.6. So since then, we've had the development plan led.
91. Before that, you simply had the duty to have regard to the development.
You had section 72, which we subsection 2, which we still have.
But you then get the greater emphasis put on the development.
Correct.
And that goes
Yes.
back.
That's
I mean, the City of Edinburgh Council case, which discussed the presumption, in inverted commas,
Yes.
in favour of the development plan, was about 1997, and at that stage both Scotland and England had identical, or near enough identical provisions.
Absolutely. City of Edinburgh is on section 18A of the Scotland Act, which was in terms identical to 54A of the English Act.
Yes.
My Lord, can I go to leave the white file out, if you'd be so kind, and just go to the authorities, volume 1, tab 1, the extracts we've got from the 2004 Act. And Mr. Kingston has taken you to some of the relevant provisions here. I will not repeat it. But could I just point, please, to page 910? Section 39, sustainable development, and my lords well understand the key role of sustainable development in the government's consistent agenda for several years now. So every person exercising a function in relation to local development documents must, under subsection 2, exercise that with the objective of contributing to the achievement of sustainable development. 3, for that purpose, the person or body must have regard to national policies and advice contained in guidance issued by the Secretary of State. So again, we find an integral part, as I have suggested, of the statutory scheme, right in the heart of what is seen as the importance of sustainable development in planning, enshrined in that provision.
Does it say what it means, though, or not?
What sustainable development means? No, there's no definition of sustainable development apart from the very helpful definition we've seen, namely everything in this framework.
Yes. It's slightly circular.
It is somewhat circular, but my lord, my purpose is not to
No.
have a debate about sustainable development. We'd be here forever. But the role of the Secretary of State.
But what is important, you say, is that applies to any person exercising a function under this part, which includes the authority.
Indeed.
Does that include the function of making planning decisions on individual
No, my lord, it's put in terms of
Policies and advice.
sorry, I put it away.
That's the expression used. Contained in guidance.
It's confined to the function of local development documents.
Yes.
So
It
it's
specifically
development
doesn't
plans.
include decision-making on individual applications.
Well, my lord, the duty is confined to any function in relation to local development documents. I had, until my lord, I think is mentioning it, I had myself construed that as the function of making and examining and adopting the local development documents. I hadn't.
Yeah, I mean, the only reason I raised it is because the point made about what the minister said was that they deliberately didn't bring in a framework of the statutory requirement under the section, the decision-making
Yes.
section.
Yes.
It's brought in specifically under the policy-making.
Yes. Yes, my lord, that is right. And of course, one never forgets, my lord, when my lord asked me that, that Section 70 and Section 38(6) bind in the development decision-making process to the development plan. My lord, I just wish, as I said I would a moment ago, the latest species of statutory development plan is the neighbourhood plan, introduced by the Localism Act 2011. The relevant provisions are at tab 4 of the white file. And in the time, I regret that we didn't have time to paginate these hard copy pages, but Lord, I'm looking for Schedule 4B, which this tab is, paragraph 8, and it's about 10 pages in, I regret. If my lords find 8, the examiner must consider the following.
So this is independent examination of the neighbourhood plan.
That's right, my lord.
Yep.
And the duty is that 1A must consider whether the draft neighbourhood development order, my lord, may I pause on order? We have put in tab 5 that for these purposes, order may be read as plan when one's talking about neighbourhood plans. So substitute plan for order wherever it appears here. Basic conditions. Little 2 are the basic conditions. The first of them, having regard to national policies and advice contained in guidance issued by the Secretary of State, it's appropriate to make the order. So again, as I would say, integral to the statutory scheme, it is dependent. It is dependent on the Secretary of State issuing the sort of policy and guidance that he has. And so, my lord, the position is that throughout the country, excluding London, which has slightly different arrangements, but throughout the country, one has the development plans formulated on this basis with the necessary guidance and policy of the Secretary of State. My lord, so that is development plan making. There is no express parallel provision in relation to the other powers of the Secretary of State. But, my lord, just a word of reminder, if I may, the powers of the Secretary of State throughout the planning system are, and always have been, very extensive. There's power to intervene in local plans. There's power even for the Secretary of State under Section 27 to make his own local plan if he doesn't like what's going on. And of course he has all-pervading powers in the development control system. A brief list: Section 77, he can call in planning applications. Section 78 and 79 tells us about his powers and duties on planning appeals. Section 100, he can modify or revoke planning permissions.
All those things, and really it doesn't help to go through them all because he hasn't done it in this case. I mean, he could have called in these two applications. He didn't. And where a decision is delegated to a planning inspector, he is exercising his own discretion.
Yes. Well, I'm not saying anything that's particularly relevant to this case in these brief remarks, my Lord. I'm just painting the...
Yeah, but I mean, I think you can probably take it that we understand that the Secretary of State has a major role in relation to the planning of the whole. And indeed, some of the provisions you mentioned are mentioned in a footnote in the framework itself.
Yes, and my Lord, I'll leave the matter. I'll leave the matter there, subject to one point. We have in this white file at tab 6, I think it is, Alconbury in the House of Lords, and it may be that my learned friend Mr. Philpott will go there. But tab 6, one finds their lordships, particularly at paragraph 140, Lord Clyde, giving a review of the Secretary of State's powers integral to the planning system, designed to achieve conformity and certainty and so forth. If there was more time, I would go there, but if my lords are happy for me to leave it with that reference.
I mean, the striking thing about all of this is that, as you accept this is a statutory scheme, and the Secretary of State has an overall responsibility, but that is done by giving him specific powers in specific cases. And the point that's being made against you is it's very striking. He hasn't done the same for Section 72 or 38, which he could have done, as indeed.
Well, Lord, he could have done, and I would say, insofar as it's necessary for any part of my argument, I would say it's completely unnecessary because, as I said a moment ago, the development plan is tied in to every single planning decision, whether it's planning applications, planning appeals, whether it's modifications or revocations and so forth.
You're saying, in effect, that the framework has exactly the same status in practical legal terms as it would have done if there had been a provision saying in terms that the local authorities got to have regard to it.
Well, Lord, yes, and because the framework, the MPPF, is a material consideration. That's not a non-statutory concept, of course. It's the statutory concept within sections 70 and 38.6, and I would simply say it's unnecessary for the reasons that I've sought to address. Necessary for there to be a specific power for him to issue guidance for those purposes.
It's having regard to the role of his guidance in relation to the formulation of the plan, and it's difficult to say that national policy is an irrelevant consideration, i.e. an immaterial consideration.
Well,
I don't think anyone's suggesting that. I mean, it's obviously material. The question is what status it has as compared to the statutory development plan. That's the issue.
Well, in terms of the statute, it has the status of a material consideration. It can have no more than that. It is non-statutory, and it doesn't have these provisions that I've looked at for development plans in development control. So, my Lord, with reference to the cases which have looked at, and I'm not going to go there, such as Shrewsbury and New London, which are in these papers, which I've looked at very carefully, my Lord. I particularly Shrewsbury, and I see the debate that's going on between Lord Sumption and Lord Carnworth to some extent.
But it's got nothing to do with this.
Got nothing to do with this. I simply say
But it's worth raising for a bit of fun, is it?
It's great fun. I've had great fun. I've been on a terrific learning curve.
But has anyone picked up the point that the case on proclamations was a planning case?
No, I haven't. But I don't need to
Possibly the
go.
earliest planning case case in the law reports.
I don't need to call on Sir Granville Ram and the Ram Doctrine and the Third Way and all that.
Yeah. Well, I think we got.
My Lord, on issue 1 in the appeal.
Thank you very much for that research that was done.
My Lord, I'm very conscious in all these submissions that this is a challenge, of course, to the MPPF, and we have the author of the MPPF represented third in the line on our side. So I am conscious of that that position. Subject to that, my Lord, the first topic I want to address briefly on issue 1 is this. There is no challenge to the framework, MPPF. In terms of plan making, my Lord, we have the linchpin of the framework, which is paragraph 14, which is a linchpin both in the development plan side of the matter and the decision-making side of the matter. And at paragraph 14, my Lord, this is, I have it separately, but it's appendix part 2, page
215.
215, thank you very much. I regret that you've got such poor copies. At the heart of the framework is a presumption in favour of sustainable development, seen as the golden thread. And then there are two sets of boxes, as it were, both starting this means that. So this is the definition of sustainable development, as the courts have recently confirmed. For plan making, this means that positively seek opportunities to meet the development needs of their area. And then this, local plans should meet objectively assessed needs with flexibility unless, and then we get identical as in part 2 of the box, this tilted balance as some of the courts have referred to paragraph 14, this very strong tilted balance that objectively assessed needs should be met unless the adverse impacts of doing so would significantly and demonstrably outweigh the benefits. Now, my Lord, that has, at the plan-making level, significant implications for the sort of constraint policies that motivate Suffolk Coastal in this appeal. And I say nothing about the Richborough policies for the time being. So, in other words, the plan must meet objectively assessed needs, subject to that very strong presumption, and therefore that has clear implications for the strength of constraint policies such as limits of development and countryside and so forth, or gaps, if you like. So, my Lord, there was complaint by Mr. Kingston as to this framework being a top-down approach. Well, there is no challenge. This might be said to be top-down. This might be said to be a strong exercise by government of a steer, as it were, but one to which there is no challenge in these proceedings and never has been and couldn't be. Lord, then we get the second part of the box, which is closer to home in these appeals, of course, which is the development, the decision-taking process. And, my Lord, can I again just test the implications of there being no challenge to paragraph 14.
You say challenge, what do you mean? There's nothing unlawful about it. The question is its status. Why should there be a challenge?
Well, my lord, it's important for the court to understand, in my respectful submission, the implications of these tilted balance, these strong presumptions, as background to these appeals. My lord, for example, you could have a policy that, a recently adopted policy, that there shall be 10,000 dwellings developed in a particular local authority area, but less than 5 years' supply emerges. The effect of paragraph 49 is that very recent policy is deemed to be out of date, and by that token may, subject always to a planning judgment, may have less weight. Now, that may seem to be an odd result, but it is the effect of paragraph 14, irrespective of any submission that the appellants may make. And indeed, if one were to step away from housing just for a moment, we're all, of course, obsessed with housing because that's what these two appeals are about, but one could have an application to change from employment land to retail, for example. Old policies preserving employment land, which are thought to, which are decided to be out of date, and then the presumption is engaged. So it is, whether in housing or elsewhere, a tilted balance or a strong presumption of very considerable significance. Well, the next topic I would like to address is this. The primacy of the development plan remains on any construction as to paragraph 49. The appellants proceed on the basis set out in their case that the intermediate, or certainly the wide construction, supersedes or modifies or discards the statutory scheme. My Lord, we say very strongly, not so. The development plan remains. It will have all sorts of aspects of land use, as we saw from the reference to the indices to the two plans. It will cover everything under the sun, from needed development to important constraints and delivery and so forth. All these still have to be weighed in the balance, as Lord Clyde has told us in particularly clear terms in the City of Edinburgh. That, once a view is formed as to conformity or otherwise with the development plan on Lord Clyde's advice, one then has to balance that against all material considerations, not simply the positive material considerations in favour of the development scheme, but the constraining elements, the environment. My Lord, nothing in the MPPF, even on the wide construction of 49, affects the statutory scheme once the statutory scheme is properly understood. It would be unlawful, I postulate, to formulate a policy along these lines: where there is less than 5 years' supply, planning permission must be granted in all circumstances. That surely would be unlawful. It surely would supersede the statutory scheme, because it seeks to completely override the statutory discretion arising under both limbs, the development plan and material considerations. And my Lord, secondly, in this topic, it has been urged by Mr. Kingston in writing and orally that the effect of the respondent's position and the Court of Appeal judgment is that one must have housing development at all costs, as he put it, at all costs. Lord, again, with respect, that's an untenable submission for the reasons I've just said, which are so obvious. That's to say, all the development plan factors will be taken into account, and all the material considerations will be taken into account. Lord, if I could ask the Court to get out the judgment of the Court of Appeal for one moment. Appendix Part 1 at the beginning. It's also in the core volume, if that's more convenient.
Wait, what page?
A paragraph in 47, paragraph 47, page 21 of Appendix Part 1.
Thank you.
Paragraph 47.
MS 276.
Yes.
My Lord, this follows the Court's construction at paragraph 32 of what the paragraph 49 means, and a discussion which follows that. But paragraph 47, the Court went on to deal with the weight to be given to out-of-date policies, saying in line 3 that it would be normally less than the weight due to policies that provide fully for the requisite supply. The weight is not dictated by MPPF, nor is it, nor could it be fixed by the Court. And if I may drop down to about 10 lines down, there will be many cases, no doubt, in which restrictive policies, whether general or specific in nature, are given sufficient weight to justify the refusal of permission, despite their not being up to date under the policy in paragraph 49 in the absence of a 5-year supply of housing land. Such an outcome is clearly contemplated by the government policy in MPPF, always for the decision maker to judge in the particular circumstances how much weight should be given to conflict with the policies of supply of housing, and so on and so forth. So that is the Court really doing, I suggest, no more than reminding us of section 70 and 38.6, that it's all a question of balance. And, my Lord, from experience, and I'm sure I can speak for everybody along the table here, one experiences regularly cases where there is less than a 5-year supply, where nonetheless one as developer is trumped by a particular constraint policy which the inspector decides in his judgment to give particular weight. He may say it's a special landscape area policy, and I find that particular harm is done to the landscape, therefore particular importance to the breach of this policy. It may be out of date, but I find that a reason to dismiss the appeal. This happens up and down the country, time after time. Well, coming to more closely to the appeals in paragraph 49, can I approach it, please, in this way? First context and then construction. And so far as context is concerned, Lord, I'm not going to make any submission about the background documents on which such reliance has been placed. I think Mr. Philpott may do so. In our submission, it's a sterile exercise because the words are in the framework as we've got them, and we don't need to worry about how we got them. The context for 49 was set out by the Court of Appeal at paragraphs 25 to 30. it is ensuring, as we've seen from paragraph 47 of the framework, ensuring that full housing needs were met. And if I could just go to the Court of Appeal for a further moment. At paragraph 28, which in the Appendix Part 1 is page 15. Is that the most helpful reference to the judgment? I don't know. If my lords are using a different reference, I'll use that.
I think some do, some.
Well,
But the paragraph numbers are always the same.
I'm a paragraph number man, my lords.
It's fine by me. If someone's working electronically, the MS page would also be useful.
Yes.
Right. Well, then there'll be a little shout from my left as we go.
You hope?
As we go along, I'm a more electronically minded man. Lord, paragraph 28 is a reference to the historical perspective of policies. Line 5, the third sentence, between 1988 and 92, there was a policy presumption in favour of planning permission being granted for housing where no 5-year supply existed in the authorities' area. And then one goes on to the later policies. My Lord, the radical change that Gallagher talked about what was, in my submission, a radical change. One had never had before a mandatory requirement to ensure that the full housing needs were met. We'd never seen that before.
That's apart from the 5-year presumption. This is the actual local plan has got to assess the actual...
Well, Lord, it's paragraph 47 of the framework.
Yes, I know, but I mean, it's separate from the 5... You've had the 5-year presumption. The 5-year
in different
supply
forms,
presumption.
in different forms, not in the sharp form we've got
You
it now.
think is getting a requirement in the plan to meet the assessed needs.
A requirement in the plan that you must meet the assessed needs is new. It is entirely new, and that was the submission I made to Mr. Justice Hickenbottom in Gallagher, which he accepted, and his judgment on these matters was wholly endorsed by the Court of Appeal. And my Lord, if I could just take a step back just for a moment, this is not a necessary submission I have to make, but the government for all the years, certainly since the war, and in slightly different ways between the two wars, has been very significantly concerned about adequate housing supply. And one thinks of the Macmillan years and so on. It would be very odd if government cannot lawfully issue and apply policy so as to steer the planning system to overcome what is, by all accounts, the critical barrier to house building. There are many others, finance and so forth, but the critical barrier is planning permission. Now, my Lord, I just want to examine the various constructions, whether narrow, wide, or intermediate, and give, if I may, these examples. If I may, there are two distinct examples. One is that you have a positive housing provision policy. That's to say, substantially more housing, 10,000, whatever it might be, in an area. You have less than a 5-year supply.
Yes.
The policy is deemed to be out of date. Paragraph 14 is engaged. It would be curious if the positive housing provision on the narrow construction was liable for full weight, but on the wide construction, constraint policies are up to date and carry full weight. The effect of the wide construction is the reverse effect to that intended under paragraph 47 to boost housing supply. It is to constrain housing supply. Or take a different example, which occurs from time to time, where you have no housing supply or provision policy at all, because you've got a very old local plan and the housing provision policy has not been saved by the Secretary of State, so it's fallen away. You've got an area with an acute housing shortage, less than 5 years supply. It, again, would be a curious position that paragraph 14 is not engaged, but the constraint policies are given full weight. Again, you have the reverse effect to that intended. And so we say, in common with the Secretary of State, who says that the effects of the appellant's construction are absurd, that that is indeed correct, because they produce the reverse effect to that which plainly arises from the context, the most important part of the context being the Secretary of State's requirement to boost significantly the supply of housing. So, my Lord, we respectfully rely on the analysis by the Court of Appeal of the proper context for the construction of paragraph 49, which is effectively paragraphs 47 with 49 leading to paragraph 14. Lord, so far as the second part of the matter is concerned, simply the construction of the words, the Court of Appeal addressed this at paragraph 32, which in the appendix part 1 is page 16. MS 271, thank you. And my Lord, I'm not going to reread this. If I may I just place this paragraph before the Court for its attention? We respectfully adopt and would endorse the entirety of paragraph 32. Lord, can I just step away from that and go back to paragraph 14 of the framework? Appendix part 2, page 215, what should be a blue box. My Lord, there was a debate this morning in relation to the Court of Appeal's judgment at paragraph 33. Sorry, I should have asked you to keep that open. So I'm asking the Court to look at paragraph 14 of the MPPF and paragraph 33 of the judgment. And it's the reference in paragraph 33 to including policies for Greenbelt, for general protection of the countryside, A's, ONB, and so forth. And of course, that brings us to footnote 9.
Yep.
Footnote 9 is surely, my lords, a complete answer to the points being raised about these wider policies that plainly not only have been around forever in planning, but are formulated to protect specific interests, whether it's the green belt around towns or areas of outstanding natural beauty and the like. Footnote 9 would not be there were it not the case that paragraph 49 applies to these constraints and these designations. They are contemplated by the author of this policy as being relevant policies for the supply of housing in both 49 and 14. As I say, footnote 9 would be completely irrelevant, unnecessary, were it not that relevant policies have a very, very wide embrace. And so footnote 9 is, as it were, coming to the rescue and clawing back the importance of these policies. And in answer to, when we were having this debate, Lord Hodges' point about designations in a spatial plan, my Lord may remember putting that to Mr. Kingston. Some of them in footnote 9 are indeed designations in spatial strategies or local plans. Green belt is designated and reviewed and redesignated and so forth within local plans. Local green space is designated within local plans. If it's helpful to have a further reference to that.
Why are they deemed to be out of date if, in fact, you're saying that they're actually clearly not out of date, they're very relevant?
Well, but
I mean, it means you're using out of date in a very curious sense. In fact, I think all you're saying is out of date actually doesn't mean out of date. It just means you give it less weight.
it means it's deemed to be out of date. I mean, these are curious provisions.
Well, I know, but what's power? I mean, that's what troubles me. What power does the Secretary of State to create a fiction that something is out of date which isn't? And when it's a policy such as the Green Belt policy, it clearly isn't out of date.
Well, indeed, my lord, but this is not an assault, as it were, an unlawful assault on the Green Belt or these other major designations, because they are accepted. And, of course, they are subject to their own very specific policies.
Well, that's what I suspect. See, all this very sort of legalistic sort of trying to define what does for supply of housing mean is really the wrong approach. I mean, basically all the thing is saying is that when you haven't got a 5-year supply, these policies have less weight unless they are in this category of specially protected thing,
Well, my lord,
which is a policy which has been applied ever since the dot. And
well, my lord, that's not what the policy says.
well, I know that's the trouble is. I mean, to the extent that it says something different from that, it introduces this very odd concept of a fictional out-of-date concept, which I find very odd.
Well, my lord, it's all...
But you have lots of out-of-time things that happen, like issuing a writ, but you
Oh, yes, they
be
are
able to
out-of-time,
get consent to get, still to be able to serve it after all. I mean, it's just...
They're done under the rules or under statute.
I must admit to being slightly troubled by the notion that you have a statutorily provided plan which has particular statutory consequences, and the Secretary of State, a member of the Executive, can, as it were, put a gloss on that plan. How does he have that power? Parliament has said this is the plan. How does the Secretary of State effectively say, no, it isn't, or it isn't the whole plan?
My lord, putting a gloss, there has always been the ability of the Secretary of State. It's never been questioned before.
Well, it
in
is
a sense,
now.
to put a gloss.
Well, it may have been assumed to be, but why? As a matter of fundamental constitutional law.
Because he's got powers to issue national guidance which fit.
Where do they come from? Where do they come from?
They come from the statute.
And how do you say that those powers are able to conflict or conflict or cut down the effect of plans that have their own statutory.
Well, that is not cutting down the effect of the plans, my lord, because
Well, it is really, because the plans say this is our policy for housing, and then the Secretary of State says, oh, well, you can treat them out of date.
yeah, but my lord, the decision maker has got to apply himself first as his starting point to the development plan, and he will note, as it were, greenbelt policy or landscape policy, and so forth. He's then got to address material considerations. The Secretary of State is, in these provisions, simply giving a particular steer as to how he wishes, as a material consideration, the development control decision to be made, not overriding the statute.
But in terms of the way in which the guidance is framed, it's open to the criticism, is it not, that if there isn't a 5-year supply, then it requires us to consider that relevant policies that constrain housing development shall be considered as being out of date, when the facts may be that they're bang up to date. It would have been much better and surely clearer to have said in the guidance that if the authority can't come up with the sites with a 5-year supply, then don't think for a minute that the constraining policies are sacrosanct anymore. They will carry less weight than they otherwise would have done.
Well, my lord, that's exactly what the effect of this framework on the construction that we urge is exactly what it's doing. Yeah. It is saying, I, as decision maker, will be minded to give less weight to these constraining policies in the extreme circumstances of a less than 5-year supply, and you are to put that in the balance. That's all he's saying. It's a factor in the planning balance. Always.
So this is a balance to be struck by the inspector.
By the inspector,
the decision maker.
by the planning authority at first instance, yes. By the inspector or the Secretary of State if he is determining the appeal. Of course, inspectors are determining it on behalf of the Secretary of State. So,
yes,
my lord,
you may get support from the view that no more than that is being said by footnote 10 itself, paragraph 14.
Yep. Page 215.
Page 215.
yes. Well, that's what I was
So
less elegantly trying to say.
Well, the tilted balance applies, but not if material considerations indicate otherwise.
Yes.
Yes.
Is that what, I'm not sure that's right, is it? I didn't understand what footnote 10 meant. I thought it was just saying that's where we get it from in law.
I see.
Maybe saying that. I mean, there is a sort of bit of problem that the writer of this does recognise that he's got some statutory backing for plan making, but he hasn't got any statutory backing for decision making, and you get that running through the thing. But anyway, I mean, in a way, it's not your job to defend
Well,
that.
it may be his recognition that this guidance is only a material consideration, and the tilted balance may be disapplied by other material considerations.
Yes.
I'm not sure if it's more subtle than that.
When did the idea of an exception, if you like, for material considerations come in?
My lord, it's always been in the Act.
I mean, it's been there all along.
It's been there since 1947. 1947 Act, my lord, was the foundation of the modern system of development control, or planning, and sections, what we now have as section 70, subsection 2, was, I think, section 14, I can't recall, I've got it in behind me.
But during in the development of the jurisprudence since 1947, presumably there's been some discussion about what was meant by this further unless.
Isn't this discussion? Don't start.
A good deal, yes.
No, but if there's some suggestion that this is ultra vires in some way, then we need to look and see just what the history of it is.
Interpreting it, I think.
To my mind, that's rather a striking suggestion.
Is it? I mean, there was a change, as you explained, in 1991 when we have the sort of added weight given to the development plan. But material considerations has always been in there.
Well, they've been there since
anything relevant to planning.
they've been there since the appointed day in 1947.
So there's always been, if it's anything relating to planning, then it's always been there since 1947 or whenever.
The development plan on the one hand and material considerations on the other.
What I'm really getting at is that one thing we have to do is to construe it in such a way as that is consistent with constitutional propriety. That's really what I'm getting at. Minor point, as Lord Cumworth says.
I think it'll be common ground that that's the principle.
Well, my lord, this is policy. This is just policy. It doesn't affect the statutory duties that the decision maker has under the statute to consider and put primacy to the development plan and so forth. It is the Secretary of State's expression as a policy implement of seeking to boost the supply of housing. And for the reasons I've said, I submit that falls squarely within the statutory scheme. My lord, that was all I was going to say on issue 1, unless I can help further.
Right.
On issue 2, we've heard nothing other than what's in the appellant's case on issue 2, and, my lord, I was going to leave issue 2 for the Secretary of State, whose written case we adopt at paragraphs 116 to 129. And I was then going to come, with the court's leave, to the Suffolk coastal policies.
Right.
And I do notice, I can start. I'm in my Lord's hands as to whether you'd want me to start this biggish topic now.
Well, you might get a few thoughts in our minds, I suppose, in the next 5 minutes.
I'll get a few thoughts in. My Lord, the position on the Suffolk Coastal Local Plan and its review, can I just, authorities 4B, tab 51, page 2387. This may be where Lord Carnworth had a recollection about a review. It may be some other passage, but...
I just picked it up from the planning inspector's decision in your case.
But, my Lord, one sees here, and I'll just come to the details in just a moment, in the penultimate long paragraph, starting nevertheless, that succeeds a paragraph which effectively says, well, it's taken us a long time to get here. And what that means is, taken together with the next paragraph, is housing requirements have moved on. And my Lord, they had moved on. Can I just put this before the court? I did put it before the court in a document and orally in the Court of Appeal. We haven't got the document here. I could provide it tomorrow morning if necessary. But the housing requirement had been found in Suffolk Coastal recently to be 11,000 dwellings. And the supply in the plan was 7,590. Now, that would normally be a cast-iron reason for not proceeding with your plan, because it doesn't comply with any of the guidance. But they wanted an adopted plan in place. They recognised the significant housing shortfall, and so they said they'd have a review, and that's what the penultimate paragraph on page 2387 is saying. And Mr. Clay took us to page 2426 in like vein.
Can I perhaps just refer you to, well, go to that, to where I got it from, just so you can look at it overnight?
Well, certainly, can I just, I'll just make this reference and then I'd be most grateful. Yeah, the other reference that Mr. Clay took us to was 2426, last paragraph of SP2, a policy I am going to come back to tomorrow, an early review. The review will identify the full objectively assessed housing needs for the district and proposals to ensure that this is met insofar as consistent with policies in the framework. Well, fine, I mean, that's how they're going about it, but of course it's the prime duty of a plan in the first place to identify and meet its full needs. My lord, yes.
Yes, it's in Appendix 1, page 93. I don't know where that's in MS terms. This is the Inspector's appeal decision, where he refers at paragraph 7 the debate about whether the recent adoption of the district plan meant that its policies were automatically up to date. And he goes on to say that as far as housing is concerned, they specifically weren't up to date because the examining inspector effectively said, well, they're not up to date, we need to review them.
Yes.
Now, I don't know whether we've got that part of the examining inspector's report. It seemed to me that what's being said there is not so much, forget about the national policy framework, they're not up to date simply because they were said by the examining inspector to need review and would be reviewed.
Well, Lord, that's what this paragraph is saying.
I think this is probably a big part of your case at the inquiry.
Well, I wasn't there.
You were, your client's case.
Yes.
No,
Well, would you like to see the relevant passage? I think it's a page or so of the examining
just a
inspector.
page. I think it might be helpful.
Yes. Have you got it now, or do you want to give us this tomorrow? Which is easier?
Tomorrow, please.
Okay.
Well,
Filled up.
Do I get the impression that's a convenient time? Very good. Thank you very much, Mr. Lockhart-Mummery. We'll resume again at 10:30 tomorrow then. Thank you. Court's now adjourned.